You're okay. It's okay.
Don't ask me to decide seniority. That's not.
Right?
Ah. You good, Judy?
Yes, I am. I have my pen.
Okay, good afternoon. I, I was, um, I was trying to figure out what the order of business is going to be. I understand that the appellants have divided up their time, so it's just a question of how much time I should allocate.
Good morning, Presiding Justice Acosta. Yes, we have allocated the time, the 15 minutes of time between us, and are prepared to announce that to the court when the court asks.
Okay, so 15 minutes is good. I mean, I know only 5 of you submitted full briefs. So I assume those are the 5 that are going to be arguing. And then for the respondents, there's only one, the plaintiff liaison counsel is the only one who submitted briefs, correct? So you'll be the one arguing.
Yes, Your Honor.
Perfect. So, okay, so tell me what the biting order is, Mr. Johnson.
Thank you, Justice Acosta. On behalf of the Defendant's Liaison Committee and the Archdiocese of New York, I will take 5 minutes and 3 minutes on rebuttal with the court's permission.
5 and 3, okay.
For the defendant's appellants, the Diocese of Brooklyn, 3 and 1.
Okay, you guys are going in the different order than Archdiocese of Brooklyn. You, Mr. Simone?
Yes.
Okay, tell me how much time?
3 and 1, please.
3 and 1. Okay, who's batting third?
Good afternoon, Your Honor. For the defendant, appellant, the New York family, we request 1 minute, with no rebuttal time, Your Honor.
I'm sorry, tell me who you are?
My name is Dawn Foster, and our client is the New York family.
Okay, and tell me the time?
1 minute, please.
1 minute. Okay,
Good afternoon, Your Honor. My name is James Flynn from the Scahill Law Group, representing defendant appellant, Roman Catholic Church of St. Clement Cook. I respectfully request 1 minute.
okay. And okay, you didn't submit a full brief, and neither did Foundling, right? But you adopted the main brief? Oh, then I missed that when I was looking at my impact. Okay,
Your Honor, we did as well. We have it in the New York family, brief, as well as a reply brief.
okay. Perfect. And plaintiff liaison counsel? We good with the appellants, right?
Yes.
Okay.
Good afternoon, Your Honor. Richard Steigman from Gary Thomason and the Plaintiff's Liaison Committee. I'll respectfully request 15 minutes.
Okay. Why don't I give you? Well, I'll give you 15. You may not need all 15, but let's do that just to be fair. Okay. I left my Surface. Which okay, Mr. Johnson, first batter.
Presiding Justice Acosta, members of this honorable court, may it please the court, I'm Peter Johnson. I represent the Archdiocese of New York, and I represent the Defendant's Liaison Counsel. And I look forward to responding to the court's questions. Briefly, we're here to right a wrong. I became a lawyer for the same reason that my father did, is to protect the rights that are instilled by the Constitution and the laws of the state of New York. And we're here to right an injustice that will have a dramatic and pervasive and pernicious effect on the law of discovery in the state of New York if this court affirms the abusive order of the court below.
So, counsel, specifically, what issues are there in terms of the order, the sharing order?
The sharing order, yes, Justice Kennedy. The sharing order.
I'm Weber, she's Kennedy.
Yes, the sharing order is a violation not only of due process, but also of equal protection with regard to defendants like the Archdiocese of New York, the Diocese of Brooklyn, and other Catholic organizations that make up the majority of the defendants in these cases. A standard is being applied to them that is not being applied to any defendant throughout New York State by the sharing order. Justice Kennedy, what the sharing order does is say,
I'm Justice Weber.
Yeah, no,
She's
he didn't
Justice
know
Excuse me,
that
I-
you asked the
She's
I'm
question.
like-
Kennedy. It's okay, I know it's hard.
I don't have my glasses on here, so I apologize.
I don't want to use up your time, but I'm trying to, so
It fogs
specifically,
up, so
it's okay. Specifically, how is the Archdiocese of New York and Brooklyn being treated differently from the other defendants? You just
because
made
under,
reference to that.
thank you, other defendants in other litigation, the court has ordered, Justice Silver has ordered, that every piece of discovery exchanged by the Archdiocese of New York and any other of the defendants must be shared with every plaintiff that is suing them, and say, well, this will be confidential. That's without a showing of materiality, without a showing of necessity, without a showing of relevance, without a notice for discovery and inspection, without the right to object to a notice for discovery and inspection, without the right to make a protective order, without knowing the discovery that's being bandied around with thousands of plaintiffs.
So you have a problem with the definition. You don't think it should be any person not reasonably involved in the prosecution. You want to change it to something else?
Justice Acosta, what I want to do is affirm and conform to what the law of the state of New York is. Make a discovery request. Have an opportunity for the defendant to reply and say, it's not relevant, it's not material, it's not necessary, it doesn't meet the Allen Collier standards or any of the standards of the New York, and say, let's litigate it. Let's know and understand the object of this discovery request. Instead, this is a secret sharing procedure. That's unlike any procedure in the United States and unlike any procedure in the state of New York. Now, that's important.
Is there overlapping discovery in all of these cases, or in many of these cases?
Can you repeat that? I couldn't hear
Is
that.
there overlapping discovery in many of these cases?
There may be overlapping discovery.
And is it your position, just so that I understand, that in each of the cases, that even if the discovery that is sought is the same, that each and every plaintiff has to ask for it individually?
Judge, no.
Okay, so then, right, and I accept that. So how would you, in looking at this order, because the order makes sense in terms of these litigations, and I mean, in a conceptual sense, we've done it in these kinds of litigations before, like asbestos litigation. How do you think the order should be crafted to address the concern that you just raised with my colleague?
And if I can just add
Yes.
to that, consistent with the efficiency and case coordination that the CVA's goal is.
Thank you. Thank you. What this order does is sacrifice procedural due process and substantive due process on the altar of efficiency, make the trains run on time, but rob litigants of the rights that they have under the CPLR. That's easily accomplished, Justice, in terms of getting people the discovery they need. It's a red herring, and it's a fictitious. In fact, it's almost forensic gaslighting that the plaintiffs are engaging in when they say, "Well, we're going to have to go in thousands and."
Counsel, I'm still waiting for a response to the question.
I'm
Again,
trying to
my
respond.
colleague asked, how would you craft these orders?
I craft the orders to comply with the CPLR. That if discovery is requested,
Let me ask
and-
you,
and the
let
court
me
should-
ask you paragraph paragraph 4, page 448 of the record, 1A, which now says, only to the following persons, the parties to a civil claim related to allegations of child sexual abuse involving one or more of the same parties or one or more of the same alleged abusers. What if that said involving the same alleged abuser and there was a provision to give you notice that this is going to be done? What would
Justice
be
Friedman-
wrong with that sort of a change?
What the court did was provide specific reference and rationale for common abusers and a common defendant, and said in those cases it has utility. But what it did was expand it to thousands of cases in which there's not a common abuser
But
and
what
there's
if
not a
we
common defendant.
limited it to to the same alleged abuser
I don't have a problem with that.
and provided for notice
I-
that this is going to happen?
I have no problem with that at all, and I don't think the defendants have a problem with that at all. What we have a problem with is this wholesale, indistinguishable, without notice determination that if I'm a plaintiff, I can take a document that you gave in a case involving an alleged claim in 1942 and then distribute it to someone in 2012 as somehow that's a relevant or material or necessary document. Same thing, a 2012 claim saying, okay, I'm going to produce everything else before that. That is a problem, and it goes to the heart of a violation not only of the Constitution, state and federal. We don't have a right to object. We don't have a right to know. We don't have a right to be heard because Justice Silver's orders didn't allow any of that. The issue is, and the plaintiff has said it really incredibly, no, you have a right in an individual case. If you object to it and you lose on your protective order, we get to distribute it to everyone. Well, the issues in case A are not the issues in case Z. And this should be a unique determination in each case. We are dealing with almost 6,000 cases. The facts are different. And Justice Gish, I would hearken back to what you said about asbestos litigation. This is not asbestos litigation. This is not a product defect.
No, I understand, but I was only likening it to the idea that a coordinated order is not unheard of in like litigations. The question is, does this one suit the needs of this particular litigation? So I don't want you to read too much into that.
I understand that, Judge, but
Don't waste your
Yeah.
time
all
distinguishing the
I'm-
litigations.
Thank you, Justice.
Unnecessary.
Yeah. What I'm suggesting and what I'm asking this court to do is to craft an order that complies with the Constitution and the CPLR. We understand, and I understand, as a father and as a human being and as a Catholic and as someone who was outraged by sex abuse, that the defendants in these cases may not be the most popular and that it's easy to pile on. But what I'm saying is when we go to a court of law and when I come to the appellate division on behalf of my clients and on behalf of all the defendants, I take seriously what's said on the statuary at the front of this court. And every law not based on wisdom is a menace to the state. This order is a menace to discovery in the state of New York and will send a signal throughout the United States because everyone follows what the First Department does throughout the United States on civil rights and on substantive law, that you don't need notice. You don't need due process. There's a different standard based on who the defendant is and whether that defendant is popular or terribly unpopular because of the religion they hold, because of the allegations that are made. That is the outrage of the decision below. And so I apologize if I'm raising my voice because I want to be heard, and it's a little bit difficult to be heard here with the masks, but it's a civil rights issue. It's a notice issue. It's a due process issue. It's an equal protection issue. And for some of the defendants, it may be a First Amendment issue. And so we're seeking redress from this court to right this wrong. Finally, may I say this? There are, and the court knows it well, there are multiple case management orders in this case. The issue in every one of these cases, and the common issue of law, is was there prior notice? The order of Judge Silver says, that's all I really care about. I'm striking out subsequent bad acts. I'm striking out subsequent corrective measures. But at the same time, we have this schizophrenic approach here that, yeah, I'm striking it out, but you can get it all from everybody else anyway. Just go down the block on Wall Street or Exchange Place. Ask your colleague on the plaintiff's bar.
Okay.
Don't tell the defendants. Turn it over. No one will know.
Yeah, we got you. Thank you, Mr. Johnson.
Thank you very much.
Mr. Simone?
Good afternoon, Your Honor. It's Christopher Simone for the Diocese of Brooklyn. With my limited time, I have 2 quick points. I want to kind of follow up on what Mr. Johnson said. Like all the appellants, we agree with his substantive arguments, but I want to give some concrete examples to kind of help the court chew on this issue, because it's not an easy thing. As you started to discuss later on in the argument, right now the ACO provides that confidential discovery can be shared in cases involving the same parties or abusers, so the same entity or abuser. That sounds pretty simple, you know, by honest terms, but it's actually cast an endless net that actually does away with confidentiality. In trying to rationalize that decision, Justice Silver kept referring to commonality, the common situation that Justice Friedman pointed to, where you have the same entity, same abuser. And he did that in a few places. That was Rockefeller University. Rockefeller University is the same entity with only one abuser in all their cases. That's a different situation than the other defendants. The Diocese of Brooklyn has 1,300 cases against it. Multiple hundreds of perpetrators spanning different decades, different locations.
Well, isn't it enough if it's just the same alleged abuser?
Well, there are some that are the same alleged abusers, maybe different periods of time, but there's still multiple hundreds of abusers, but it's still the Diocese of Brooklyn. Under the ACO, every one of those 1,300 plaintiffs can share confidential discovery with every other plaintiff for the simple reason that they're allowed to share
About
it with the
everyone,
same entity.
about every abuser.
No, but can share it with every other plaintiff because they sued the diocese, and since the ACO allows it to be an or situation rather than an and, I can't help but think
But the
of...
plaintiffs are sharing the information as to all the abusers, the alleged abusers.
They can share any confidential information they get in one case with all 1,300 plaintiffs because they all sued the diocese. That's the or. We need an and here. In the and situation, the common abuser, common entity, it makes sense to share because it's the same discovery. But basically, there is no confidentiality for the diocese here because all 1,300 cases are fair game. You can share it with everybody because the court said same entity or perpetrator. It's an and or situation.
So if it was limited to the same abuser, you would have no objection?
It would make sense if it's the same abuser, and there's obviously, that goes into my next point of the burden shifting of relevance, then obviously it makes sense. We're doing that in those cases because especially when you have the same firm representing all these plaintiffs, it doesn't make sense to disclose it multiple times. It's the same information because it's the same abuser. But right now, you're talking about hundreds and hundreds of cases that are fair game. Everybody can have it without any showing of relevance or necessary different decades of abuse, different locations. It's just, there is no confidentiality.
Okay, you got a little time. If you can address the placement of the burden.
Yes.
Showing on confidentiality on the defense.
I can do that very quickly.
Okay.
I don't think there's any dispute that the normal practice in New York is that, under the CPLR, you object to something as privilege and it's not obtainable unless the receiving party establishes via motion that it is. And then at that point, you have to...
But the burden of proof still heavily weighs in favor or weighs on the party who's claiming the privilege or the confidentiality, correct?
When the motion is made, yes, we have to present proofs.
So the only thing you're really arguing about is who has to make the quote-unquote motion?
Well, essentially, but let me
So why
what we're
does that
advocating.
really matter,
Well, Judge,
honestly?
because it's not New York practice, Judge. What we're advocating is follow.
Actually, I didn't understand that, but go ahead, tell me why you think that's not legal practice.
We have advocated following the commercial division rule, okay? The commercial division rule puts it on the receiving party to initiate the motion, and then obviously everybody presents their proofs. We know that rule works.
There's
Why?
no real reason one way I mean, I had a little trouble wrapping my head around this argument because to me, the procedural mechanism really has not much to do with the burden of proof And it's just a mechanism.
Well-
And one of the important things that should be under this order is that there is a mechanism to get the dispute to the court so that if there is a legitimate dispute, the court can resolve it.
Well-
Why should it matter? Why is it
Yeah.
such a
I can explain
burden
that. I can
to
explain
make a
that, Judge.
motion?
Because the CPLR says that a party can object to something as privilege, and then it's not obtainable. Then it's up to the other party, because that's what the CPLR says.
No, but see what the
Votes for protective order. It's not that
But
clear.
the legislature
You
didn't
can-
do away with that. They opened up the statute of limitations, but they didn't change substantive rights.
Can you address the court's concern, the trial court's concern with basically the defendants designating each and every document confidential, and therefore forcing the plaintiff to make myriad applications seeking to unseal records?
You know, I can't
So
address.
we're going to spend the next 10 years, given the 6,000 cases, how long is that going to take? I mean, we got to try to build efficiency.
I can understand that, and we're all in favor of efficiency, and that's why the defendants' counsel and the plaintiffs' counsel got together, submitted proposals, and have been working on these cases together for 2 years.
Okay.
The way I can address it is, stick with what works. The commercial rule works. It's not a problem. The reason we know it's not a problem, there's no appellate authority saying it's any problem.
But-
There's no
but wait,
cases on it
but
because it
here's-
works.
Here's the problem I have with what you're saying. Somebody's got to come forward and make a motion to put the dispute beforehand. You can use the commercial rules as a model, but God knows they're not necessarily binding in this context, and the court can craft an order figuring it out. You say, gee, the plaintiffs, they're just going to object to everything. They say, oh, if you do it the other way, the defendants are just going to mark everything confidential. It's actually upsetting that each one of you has so little confidence in the other, but okay, it's good to be skeptical. Somebody has to play chicken, and I don't understand why it's an abuse of discretion for the lower court to have decided you.
Because the CPLR says that the procedure is you can object to it and it's not obtainable. That's why. That's the practice in New York. We're only advocating for what's already the
You don't
practice in
think
New York.
that Article 31 discretion covers that?
If the other way, if the ordinary way didn't work, you would have tons and tons of cases saying it's not working. There's no authority saying that the commercial division rule doesn't work.
Okay.
We know it works, so why change what works?
Okay.
Thank you very much.
Thank you, Counsel.
Good afternoon, Your Honors. We represent the New York Foundling, which is a child care agency which provides, among other things, foster care services and adoption services. We wanted to briefly address the CMO2 and the ACO's failure to comply with the social services law, and particularly Section 372, which deems confidential all records maintained by a child care agency. The statute also requires that the records be safeguarded from inspection for those persons not authorized. Case law interpretation of this particular statute requires that an in-camera inspection must be conducted to review for the relevancy, materiality, and necessity of the disclosure of the records before they are.
So since these records are already, I mean, you yourself agree that they require heightened protections, right?
Yes.
So why? I mean, it seems to me that there's already a provision in the agreement that covers you, no? The no waiver provision, for example, already preserves the right to object to discovery requests for those records, right?
Yes, that is
So
correct.
what am I missing?
Well, right now, we represent the New York Foundling in approximately 50 or so cases. And as currently written, the order requires that we furnish all of the records without safeguards. We could file motions in every single case.
Right, you got 20 days to file any concerns, right, according to the order, Section 4(1)A.
Right. We have, Your Honor, we have started to file motions seeking an in-camera inspection. However, this is going to require numerous duplicative motions that we think can be streamlined if a certain, whether it's JHOs or referees or judges can help us begin performing in-camera inspections so that we can disclose the records instead of making duplicative motions for all of these cases.
And so again, what modification are you requesting?
Well, we would like the ACO to be modified to reflect the proper procedure, which would require an in-camera inspection to determine whether the records are relevant, necessary, and required for disclosure. The records also...
So how would you, I mean, mechanically, how would that be accomplished? In other words, suppose we agree with you, the law requires an in-camera inspection. How do you get that, or what provision should be included within the order to otherwise mechanically have that happen?
At this point, the plaintiffs must respond to the standard discovery demands. Once those responses are received, we would be inclined to provide the court, eliminate the motion altogether, provide the court with the set of records, our proposed privilege log or confidentiality, those things marked confidential, and then we would have an in-camera inspection with all parties and the court to determine what's relevant and necessary. This is the procedure if we weren't dealing with CVA.
Is there a coordinated place where, or a judge or a special master or a designated person who is overseeing the implementation of these orders? In other words, that might work if we have a person designated to know that the response is requiring camera.
Right, at this point, we don't have that, Your Honor, because the orders below do not dictate or provide for an in-camera inspection, which requires us to make motions on every single case.
Yeah. Okay. Thank you, counsel.
Thank you.
Yeah, maybe,
Even if they did,
require that.
yeah, it could be, even if they did require cameras, you need a mechanism to get it in front of the court without a motion. Okay.
Yeah, that makes sense.
Good afternoon. May it please the court. My name is James Flynn. I represent the Roman Catholic Church of St. Clement Pope, one of the 150 or so parishes located in the Brooklyn Diocese. We also represent the other parishes in the Brooklyn Diocese, as well as numerous other schools, academies, and other charitable institutions. The confidentiality order is one thing it doesn't do. It doesn't protect confidentiality. And the burden imposed on the parish or the parishes is not light if they want to somehow protect their rights. The parish is named in something like the parishes are named in over 1,000 cases in the diocese, and in almost every time, by my count, it's 1,025, a co-defendant is the Brooklyn Diocese. And under the confidentiality rules, anytime we produce something in this case, because the Brooklyn Diocese is a co-defendant, everybody gets it. What does that mean?
So would you have, I mean, you're repeating the problem from that's been reiterated before, which is, would you find a suitable solution limiting that disclosure where there are common abusers as opposed to parties?
Well, I would agree with the co-counsel. We could handle it if it's the same abuser, and if the procedures are in keeping with the CPLR, which is the burden shifting issue. But if you...
Well, explain to me again, because obviously I'm the one having problem with why that burden shifting is such a big deal.
Well, the CPLR...
The burden in terms of legally proving entitlement to the protection of the documents is on the person who is saying no discovery, right?
Right. Yes.
It remains the same.
The burden once the motion is made. But who's the initial burden on? The CPLR could not be clearer on that. 3111, 3122A1, 3124. It's the party requesting the documents. It's very clear who has to initiate.
So what? It's got to go before the court. So what?
But here's the point, is that who initiates the process? The way it stands right now, just by saying I object to it, we would have 10 days to make a motion to protect.
But aren't you the one who initially makes the designation of confidentiality?
So once we do, we meet and confer, And if the other side wants it, they should do what every other party in New York and in the United States does. They move to get what they want.
Well,
If you want it, you can move
that's
for
not true all over the United States. You can still, there's the right to move for a protective order when you want to protect information. So I don't understand why the motion is such a big deal. That's me personally, but I'll talk about it with my colleagues.
Your Honor, there are,
Your other issues are different, they're more substantive, but this,
There are
who makes the motion?
there are over 1,000 cases against the parishes. That's a big burden.
Right. No, no, it is, but you agree that the underlying concern that the trial court had with you designating every document confidential and then therefore triggering motions in 1,000 cases about which of those documents are and are not makes it impossible.
Well, what's the converse of that, Your Honor? Wouldn't the converse be saying, I want those documents? Then that's the opposite expedient. It's the same thing either way. Let's go with what the CPLR says.
It actually is the same thing either way, which is why I'm so confounded by this. And the CPLR made it, whatever they picked, they picked. It wasn't sacrosanct, that's not constitutional, and that's not an abuse, I don't think it's an abuse of discretion.
Yeah, I wonder
for
whether
the
the
court
CPLR,
below.
whether the legislature contemplated
Yeah, they could have done it the other way, and it's
when they were crafting
okay,
this
right?
discovery orders.
It's
But
not-
they did.
But the substantive issues are different, and I will allow that.
But the legislature did consider a fair and efficient and due process way of resolving this dispute.
Indeed.
And the CPLR covers it.
Okay,
Any other
thank you.
questions?
No, we're good. Thank
Thank
you.
you, Your Honor.
Okay, another minute, and we get to you, Mr. Stagman. Don't worry, we'll get there.
May it please the court, my name is Nicholas Herzler, and I represent the Society of African Missions, and I have a little bit of a unique issue, and it's only for a handful of cases, but we feel that there is a material conflict between the amended order and the GDPR, which is European law concerning the sharing provisions. There's no dispute that the GDPR does apply to my client, which is primarily based in Ireland, and also in Rome. But the plaintiff's arguments, substantive arguments that they're making in their brief are unpreserved for appellate review. They do not dispute that the GDPR does apply. It puts us in an impossible position because we...
But you also agree that, using criteria that have been laid out to deal with comedy, the fact is that if we have jurisdiction over you, we can craft an order pursuant to U.S. laws, New York laws in this case.
Well, of course, but these federal cases that we cite in our brief simply say that although the court can do that, there should be a balance. There should be a striking of a balance.
Right, but the federal courts in the Second Circuit have also crafted, as I mentioned before, factors that we need to evaluate, such as the importance of the documents in question, the degree of specificity request. There's a whole...
Right. Well, the main, really, Your Honor, the main point I want to make is that the plaintiffs basically in their brief, what they mostly say, the way I understand it, is that it would be much more convenient for us if we did not have to consider this problem of a conflict of laws. And what I'm saying is that we're only talking about a handful of cases. So it's really not a big convenience problem for them. And so to have the ACO be amended to
How many cases are we talking about? And that's now, right?
Okay.
That's not to say there won't be more.
At most, 4.
Right now, right?
Right, there's actually 2, because 2 were dismissed in the lower court on personal jurisdiction grounds.
Okay.
I don't know if they're going to appeal that, and but at most, we're talking about 4 cases. So I don't think it's asking a lot to have it be amended.
Can I ask another question?
Yeah, go ahead.
Yeah, so I'm going to ask you what I've been asking your co-counsel. What language would you propose to change in the current order to accommodate the need for these particular cases?
So we wrote that in our brief at pages 16 and 17. It's not a quick answer because it's not the simplest issue.
Fair enough.
16 and 17.
Yes.
Yeah, I left my Surface computer, so I
Unless
would
there
have
are
it
any...
in front of me if I didn't.
Thanks.
Problem with technology.
Yeah, I understand.
You
Your
can't leave it in chambers.
Honor. Thanks for listening.
Good, thank you. Mr. Stegman?
Good afternoon, Your Honors. Richard Steigman for the Plaintiffs' Liaison Committee. These are difficult things to talk about, and they're difficult things to think about. But talk about them and think about them we must. And the scope of discovery in this case must be governed in light of the underlying facts that bring us here. And those are the tragic truth that for decades,
You know, can we, I think we're all aware of the seriousness of these cases and how important they are to both sides. So I think the better part of argument today would be to talk about why the provisions that exist are what you need in order to go forward on your cases, and why the requests that are made, which quite frankly seem somewhat limited in scope, are not, or should not be allowed, or somehow we shouldn't consider them.
Right.
Thank you for that, Judge Gish. The answer is because these defendants engaged in a pattern and practice.
That was going to be my question. I know that there was some discussion about let's limit it to one abuser, right? And so my question was, are these also lawsuits against the archdiocese in general in terms of what they did or did not do in relation to those individual abusers?
I'm not sure I heard every word of your question, but so let me, if I am not being responsive, please just let me know. But the claims are, yes, that the defendants, these defendants, the different archdioceses, knew or should have known about abuse in any particular case.
Right.
And for that, they are liable.
So therefore, you would need to know you would need to establish a pattern, and in doing so, you would need to know broadly all of the information as to all the alleged abusers.
It's absolutely relevant, or has at least the tendency to lead to relevant evidence in this discovery matter.
So each plaintiff is suing not only the individual abuser, alleged abuser, but also the archdiocese and the other defendants as, I don't want to say supervisor, but also as the overall entity, the entity over that alleged abuser.
That's exactly right, Judge Weber. And imagine what these defendants want to do. Not in the name of upholding the Constitution or standing up to religious haters. That's an offensive concept, frankly. What they want to do is convince this court at this point, when we're just engaged in discovery, where the standard is, did the court below abuse its discretion? They want to have you say, as a matter of law, if there's 6,000 cases, there's 6,000 isolated incidents, and if you have a claim regarding one priest that abused 15 or 20...
I know if you're limited to alleged abuser, that doesn't mean that there's 6,000 isolated incidents. It means all of the incidents involving that alleged abuser are connected, and there would be discovery of that. It's not limiting it to just individual cases then.
So let me run with that. Let's say there were 1,000 priests that did the abuse. That they still would say to you, so it's 1,000 different priests with 1,000 different stories. But what if I told you that a bishop who was in charge of multiple abusers actually said to himself, you know, I've learned about what's going on in this parish, and if it gets out, it's going to cause terrible damage to the reputation of the church. We do wonderful work here. And if people know what's going on, it's going to hurt our institution. So rather than call the police and warn the parishioners, your child is at risk, they said, leave Brooklyn, go to Buffalo, meet new children. And if I say to you, that's what they did, it would never be appropriate for this court in this moment to say, don't let a lawyer who has a case involving abuse by priest A learn anything about how the church and the diocese handled abuse by a different priest going on around the same time. This is a pattern. This is a pattern and practice. You know, if I stood before this court and I said to you, the way the church handled this was hypocritical, and it was an example of the exact opposite, how this should be handled, Judge Gish, you might say to me, no, we don't need those kind of words, counsel. That's not appropriate. Those aren't my words. Those are the words of Cardinal Dolan, which he spoke on national television a couple of years ago.
No, I wouldn't say that, and I think you're misunderstanding. We have limited time here, and we understand the seriousness of these cases. It's apparent to all of us from both parties' point of view and the consequences of these cases. What I'm trying to understand is how the cases should move forward. And the passionate arguments, as passionate as they are, they don't help us right now, because what you're talking about, that passionate part of the case is not going to resolve the limited dispute that we have here. So I don't actually think that's a fair representation of my trying to get you to focus in on specific questions we have about whether this order should or should not be changed in certain limited ways.
No, I appreciate that, Your Honor. I'll give you the everyday pragmatism of it. I've never in my life heard of a situation that they seem to suggest, although they offer no real-world suggestion. We have bishops that are going to need to be deposed. The reason we have the statute, and along with it came 202.72 that specifically directed this type of multi-county litigation, is so these cases could move forward. It would be, the directive was get these cases on the trial calendar in a year, a goal long since passed. But if we were to depose the same bishop 500 times in 500 different cases, it would be absurd. We all know that. So if we take a bishop where there's overlapping claims involving different priests that he supervised, I've never heard of such a thing, that one lawyer would offer an exhibit regarding an information, and everybody else who's present at the deposition would say, avert your eyes, you can't see it.
So, counsel, what is your argument as to New York Foundling Hospital in terms of their arguments, I guess, as to the confidentiality of those records?
That this is an order, well-crafted, frankly, that sets forth ground rules. It doesn't make a definitive determination.
So what about their, what's your response to their argument that there should be an in-camera, there should be a requirement of an in-camera inspection of the documents?
Well, I don't know that they have a de facto right to an in-camera inspection for every single document where the parties might be able to agree.
But you agree that these foster care records, you know, the legislature has exercised a policy choice, right, to protect them?
But it's not inviolable, as I understand.
No, I agree. So the question is, and this is all we're trying to do, Judge Gish, and I know there's been much discussion, but we're just trying to give you a set of rules that's fair so that these issues can be properly adjudicated. That's what we're trying to do.
I agree with that, Judge Acosta. You pointed out there's a no waiver clause. So, you know,
But adoption records, foster care records, they start off being considered confidential, do they not?
Right.
They do.
So is there anything wrong with the proposal made by the Foundlings Council that all of these records go for an in-camera inspection before they're disclosed?
All any defendant has to do is say, this is confidential pursuant to this statute. We're not producing it for
But the way
these
things
reasons.
stand now, they'd have to make a motion for that, wouldn't they?
Within 20 days.
Yes.
But you did agree that there's a heightened protections for foster care records.
I
So
think
given that, why not have them subject to an in-camera inspection?
Well, as I said, I think the defendants are entitled to ask for that. I don't think a decision on whether or not they would get one is even in this order before the court. I appreciate the court's point. These are ground rules.
Are you
but-
saying that we shouldn't be ordering that this be resolved by an in-camera inspection?
Well,
The
if you're asking
founding-
me,
The records of adoptions?
I don't have a problem if there's an in-camera inspection of adoption records. There certainly is no appropriate argument here that those statutory protections serve as a sword, serve as a protection against victims of abuse, getting certain records about what people knew or should have known
But
about foster care.
as I understand New York Foundling's argument, it is that, look, these records are always considered confidential. Before they're turned over, they should be examined by a judge, or if there's a special master looking at it, that should make a determination whether or not these records should be turned over.
I think the point, I don't see anything in this order that's contrary to that.
So it doesn't provide for it
Well, it does. It does provide for it. It
upon
says that-
motion.
Yeah.
But it's a cumbersome mechanism, is all that's being said.
Well-
What would be your objection to having a less cumbersome mechanism for things that are presumptively supposed to be kept confidential? Everybody gets the substantive ruling, and you talked about the parties agreeing. You could always agree. We're all for agreement outside of the mechanisms provided in the order to turn over documents or not. But what would be the problem, really, for you, for the foundling to have an expedited mechanism for an in-camera review of records that are presumptively supposed to be kept sealed and confidential?
As long as the proper standards were applied to discovery, I have no problem.
We don't have a problem, but, you know, even the social service law, I mean, you yourself said that the question is whether these are the appropriate circumstances under which the confidentiality that the statute provides to these records is used. The question is whether a special master looking at these records before they turned over, like, that seems to me a logical way of avoiding unnecessary motion practice, et cetera, et cetera.
I have no dispute with that. My biggest concern by far on behalf of the Plaintiffs' Committee from what I've heard today is the notion that they only, and by the way, the idea that they can't find out who records are shared with. They can ask. There's no prohibition
I'm sorry, I
in
didn't-
this order. Who did you share it with? Here's who we shared it with.
I don't know that the problem was that they would not know who it was shared with necessarily. I think it was also that it would be shared with hundreds of individuals, or thousands of individuals.
Everyone pursuant to this order who gets this information is bound by the same confidentiality order.
But you don't have to tell them who you're sharing it with. Even under your scenario, they'd have to ask you, right?
I think that's right. I think
And
if they-
there's no temporal limitation on that. So in other words, you get something today and you share it with somebody for 5 years from now. If they don't ask you 5 years from now, who have you shared it with, they're not going to know.
Look, you've asked a lot of pragmatic questions. This is it. The statute is now
I'm
gone. These
all
are the
about
cases.
So the current language under section, oh, don't worry about the clock. I'll take care of that. I'm sure they got something like 30 minutes because I kept extending the clock. So we just want to get to the right place.
No, when I say this is it, I mean, this is the time. We need the documents. We need them for the depositions. The idea that they're going to be surprised by being confronted with their own document is somewhat disingenuous. And this is nothing more than strategy. The whole point of this statute is to shine light on what happened. I know I seem hyperbolic, but it really is what's
We got
going
it.
on.
We got it.
And if you say, look, it's not fair if you're going to talk about one priest and now you'll talk about the other, I could give you so many examples, because I know these cases. If I told you about a story where someone complained to a bishop, there's a child's bicycle outside the rectory at 10 o'clock every night. I see this bicycle, and I've noticed this child sits on the priest's lap, and I'm concerned about it. And the bishop said, well, he's a great guy. That's innocent. He loves the children. He's affectionate. And they argue, well, we're not liable. We didn't know that there was sexual abuse going on. Now, what if I told you those were common characteristics among abusers that had happened in several cases? And they knew that this was something that's a characteristic of an abuser, and they said, shh, keep it quiet, don't tell. There's something so pernicious here, and it's why it all ties together. We're not a trial. I understand at trial, they could stand up in any particular case and say there's information that was disclosed that shouldn't be offered in this particular case. It would not be fair to the plaintiffs to say I have to establish a burden of relevance or admissibility on discovery. But there is something that we all have to deal with, that what is going on here, if you could imagine, there is someone who had these predilections, who's in the church, and who said to himself, well, I have these feelings, but I recognize this is immoral. I recognize I'm putting my liberty at stake if I behave this way. And that person sees what goes on with the priest next to him, and he sees, rather than the police being called and that person taken away in handcuffs, he sees that person reassigned to find new unsuspecting children. He very well might say to himself, you know, this is a safe haven. And this is not anti-religious. The church does fantastic things.
Thank you, Mrs.
But they didn't
Chairman.
hear.
I think Judge Weber has a question.
It's Kennedy. I have a question.
Oh, I'm sorry.
No worries, no worries.
Well, she passed it, she passed it
Yes,
to me.
thank you.
so-
No worries. No worries. Counsel, can you respond to Mr. Johnson's argument that there should be language included in the sharing provision regarding notice being given prior to disclosure? Can you address that?
My response is, if they want to know whom documents are shared with, they simply need to serve a demand. Who did you share this with? It can't be shared outside the circle of people who were bound by confidentiality. They can't be surprised or aggrieved by being presented with a document that they themselves have produced. If one lawyer had all of these cases, this whole conversation would be nonsense, wouldn't it? It would all go to the same lawyer and they'd all have it. So now what they want to do is break us all up so that none of us could someday stand before a jury or stand before you and say, I've got all the facts I need now. Let me tell you what really happened here. This is strategy, and that's the answer. What would be unfair, what would be the abuse of discretion is saying, at this stage in the game, in discovery, don't even let lawyers get the information if it goes beyond the particular priest who abused a particular child, because we don't want you to see the whole story.
Okay, go ahead, Judy.
So you gave an example of why we shouldn't limit the production of documents just to abusers and parties, but it should be or parties, which it brings in all documents related to all abusers from institutional providers, correct?
If there's a common defendant. In other words, I can only share.
But the common defendant can be the institutional provider.
Yes.
And that seems to be one of the flashpoints for the argument here. And so my question is does the order as it's written then, is it over-inclusive in that everybody gets it? And would there be a way to get that kind of information in the cases where we're trying to claim a practice and pattern against an institutional provider?
Respectfully, I think that's a trial question. If the same bishop for 30 years, if we assume for the sake of this conversation that one person who ran one particular parish, and he spent 30 years doing everything he could to ensure none of this information came out, and one thing happened in 1950 and another thing happened in 1980, but I ultimately proved to Your Honor that for whatever his motives were, it was a person in authority whose intentions were to ensure that when these things were reported, appropriate action, preventative action, was never taken. 30 years apart, wouldn't it be relevant?
No, as I said, you described the circumstance, but of the thousands of cases, those aren't all the cases, are they? They're not all patent and practice cases. Some of them are individual cases. Some are negligent hiring and retention of particular abusers. In other words, I'm just trying to understand if this is, by including parties, it is over-inclusive and you can otherwise get that information, or the answer is no, it's in every case, and therefore the information is necessary across the board.
So number one, I don't see how we could get the information if it's subject to a confidentiality order, and there's a limitation in the sharing so that it can't be shared. I freely acknowledge.
Well, couldn't you as an attorney make a request for that information in a particular case, and how burdensome would it be?
Overwhelmingly burdensome to suggest that before any documents are shared, I should figure out, in my case, which are the relevant ones to which I'm entitled to discovery.
But if it's two different alleged abuses, wouldn't you know under which bishop's supervision those abuses operated?
How would I know unless I have the records?
You would know when the bishop was assigned to the archdiocese, when the bishop was assigned to that parish.
But I wouldn't know what his involvement was in another case without actually seeing the records. And again, just as a practical matter, if we're going to be
But why
together...
wouldn't you know that from knowing about each alleged abuser?
I'm sorry?
Why wouldn't you know that by knowing about each alleged abuser?
Because I'm under a confidentiality order. If there's another attorney who represents another child who was sexually abused, who was raped by a different priest, and there were complaints that went to a bishop, but I can't see any of those records, how would I know if I can't even reveal to another attorney the information that I've received and what he or she has received? How can I make that call? How can the equities at this point fall in the prevention of disclosure? If it's over, you know, when you talk about it being too broad, so there's disclosure, all of which is subject to a sworn confidentiality order and if anyone ever broke it, there ought to be swift and severe justice for any attorney or party who doesn't follow that order. But the right remedy is when we get to summary judgment or we get to trial, you say, all right, you received, this information was shared with you. Sorry, Steigman, it doesn't come into evidence. Go prove your case with the documents that are appropriate.
Thank you. Thank you, Mr. Steigman.
Thank you, Your Honor.
Okay, you got 3 minutes, Mr. Johnson.
Let me address the mistakes of law and mistakes of fact, and I won't characterize them as fabrications. The law of the state of New York is not pattern of practice with regard to child victimization. The law of the state of New York is prior notice and notice of propensity. General awareness, and our brief lays it out in multitude of places, is not the law of the state of New York. This is not a civil rights action. This is not a 1983 action. Pattern and practice is not the standard. Pattern and practice was not before the court below. The conduct of the bishops, which is not part of this record, part of a fictive hypothetical, part of an effort, unfortunately, it seems, to defame bishops, and I don't know why Cardinal Dolan's name was into it in this context, and I object to that, and I was going to object to
My
during it.
question was posed as to whether or not there was causes of actions, separate causes of actions as to the archdiocese. That was the basis of my question, and I thought that was your adversary's response in terms of a pattern of
The
practice.
cause of action against the archdiocese is for negligent hiring
Right.
and retention. But pattern and practice is not the issue. The issue,
Well, is it only negligent hire? Is it also negligent supervision as well?
yes, but again, Justice, the issue in those cases is only not a general awareness of the issue of child abuse.
No, I understand.
The issue is a notice of a prior propensity. And so the question has not been answered by my distinguished colleague with all these attacks on the Catholic Church and on bishops and hypotheticals that are not in the record, and I'm surprised, frankly, to hear it, because it's to whore the record, and it's not part of the legal issues in this case.
Counsel, I wanted to, before your time is up, the question in terms of the sharing order, was there any request that you be made aware of who the information is being shared with, or any request that it be for a specific period of time?
We objected to it, and there was robust practice before the court. There was also motion to vacate what the court did, so the record shows our objection from the very, very beginning. What hasn't been answered, Justice, is the issue is this. Why are the plaintiffs, given that there are meritorious claims, and Cardinal Dolan, since you raised him, went out and got a loan of $60 or $70 million years before the Child Victims Act to settle claims, and has said publicly that meritorious claims need to be settled. So the attack on the Cardinal Dolan is not necessary. The issue is what.
Actually, I don't think that Mrs. Steigman made a statement that was derogatory of Cardinal Dolan.
Well, he's talking about
I
the
think
bishops.
The reference was actually a positive reference to Cardinal Dolan, that he recognized the issue early on in the process.
Thank you, Justice Costa. What I'm saying is he hasn't recognized, the plaintiffs have not recognized, that their case is not immune from the CPLR or the state constitution or the federal constitution in terms of notice. And what Justice Gish was talking about on confidentiality, let me apply that to this, the burden, whose burden it is on confidentiality. Whose burden on discovery is it to show that the discovery is material and necessary and relevant? It's the plaintiffs. And why are they immune from that burden? Why are they excluded from that burden? Why has that been erased from the CPLR in these cases? The court below says convenience. The court below says, well, you know, this is going to cause a lot of aggravation. The truth is there are massive, and they're being worked on right now, case management orders. The defendants in each case have to turn over the personnel files, the complaint files, everything about that alleged abuser that will show the quintessential issue in these cases. This is the quintessential issue. Is there notice of propensity? This nonsense about pattern and practices and about afterward fraud and the bishops knew about it and they covered it up. These lawsuits don't have cover-up allegations. California, that's a statutory cause of action. That's not in this case. And they haven't justified, after hundreds and hundreds of pages of briefing, why they should evade the CPLR, why we shouldn't be given notice of the discovery that they want. I printed last night a whole bunch of notices. Notices of appeal, notices for discovery inspection, notice for motion for protective order, all kinds of notices. And I said, you know, notice is the linchpin of our justice system. I got a notice here yesterday from this honorable court say, be here at 12 o'clock. The reason that we're here at 12 o'clock is that we filed a notice of appeal and said, respondent, respond to it. Plaintiffs want to evade that. Plaintiffs want to say, you are a bad class of people, and you're not entitled to the rights that other New Yorkers and other Americans have in this court. So I'm appealing to this honorable court to say, that's got to stop. That is the quintessential definition of what an abuse of discretion is. And unfortunately, the court below was swayed by some of the stuff that we heard here today about this parade of horribles of how bad bishops are and how bad institutional defendants are. Their brief goes out of the way to say that the defendants are good at covering up cover-ups. That's, even if that were true, which it is not, that is not a basis to eliminate the CPLR and eliminate the Constitution of the United States and the state of New York. And we asked this court to vacate this order. We're open to an amendment with regard to abusers, individual abusers, but to say you can distribute thousands of documents involving foster parents.
Well, I mean, I'll end it here, but, you know, that's why I think every time you bring these issues to the court, you're going to get a decision that we deem fair and it complies with the law. Eventually, you folks are going to need to be at the trial level and have the level of cooperation that is going to be necessary to move this case.
We've had great cooperation, Justice Acosta, for 2 years. We've been meeting in my office, Dunkin' Donuts, sandwiches. Before the pandemic, we got along well. This is a problem because above all, we need to be lawyers and great judges like this bench is and we need to conform what the law is. There are no special rules for special plaintiffs or special defendants. We
We
just
got
want a
that.
fair
We got
playing field,
that.
and we know we'll get a decision based on the law.
Thank
We
you,
thank
Mr.
the court for
Johnson.
this extra
Thank you,
time
Mr.
today. We
Steigman.
Thank the court for being here in person. Thank you.
Thank you, Mr. Johnson. Thank you, Mr. Steigman, and everyone.
There's 1 minute yet.
Oh, no, I didn't give you a rebuttal time. Oh, I apologize. You're right. You did get 3 and 1. The others got 1 minute.
Sorry, I'll take 30 seconds.
We got a 2 o'clock bench, so.
I know. I'll take 30 seconds on the burden shifting. I don't remember the name of the case, and I'm probably misquoting it, but Justice Cardozo once said that judicial discretion is not the arbitrary will of the judge, it's canalized between opposing banks of reason. If the reason for shifting the burden of confidential designation is simply based on a suspicion that the defendants would abuse that, then I think that itself is an abuse of discretion. Mr. Steigman is very passionate about this case, as he should be. We can all agree that these all come from terrible circumstances. But I represent the Diocese of Brooklyn. I'm not the Diocese of Brooklyn. I'm an attorney, and I'm an attorney bound by an oath. If I'm going to use the CPLR as it should be to designate something as confidential, I'm bound by an ethical obligation to do that. There's no basis to think that because of what happened in the past with the churches, that they're the ones designating this. This is all done by attorneys, and it's already controlled by the CPLR and rules of ethics.
Got it.
We're just
Thank
saying,
you, Mr.
leave it the
Simone.
way it is, it works. Thank you very much.
Thank
Have
you,
a good
Mr.
afternoon.
Simone. Bye-bye. Take care.
Thank you.